Okay, it's 9:01 a.m. and good morning, everybody. Just by a show of hands on a video, can you hear me? All right, thank you very much. That's the first obstacle that usually goes wrong. That'll leave a few other things that could possibly go wrong. Anyway, my name is Jeb Penny. I'm an executive advisor with the Public Service Commission, and today we are here to take public comment on 807 KAR 5:015, which is the Commission's proposed regulation to address pole attachments. I sent out a calendar invite earlier this week that included a list of participants, or an anticipated list of participants, as well as the order in which we would like to hear those participants. I would appreciate if you or your party are not speaking, that you mute your microphone and also mute your video at the same time, and refrain from interjecting or asking questions. We're here for comment. We're not here for cross-examination. I will do my best not to interrupt any speakers, but if there is an issue that I think will require clarification, then I might follow up with one of the commenters on that. And there are no time limits on the initial comments. If time permits, I might allow response comments if people want a second bite at the apple. Written comments on this regulation are due to be filed no later than 11:59 p.m. on July 31st. I have already received several written comments, but not an exhaustive list from those that I would expect to receive. Those will eventually be posted on the Commission's website for everybody to view. I've already, under normal procedures for the regulation, the Commission's statement of consideration would be due to be filed with the Legislative Research Commission sometime in mid-August. I believe it would be August 13th. However, because of the length of the comments already received, the Kentucky Broadband and Cable Association had to send it to me in a zip file because of its length. And because of the length of other comments, the Commission will be asking, or will be invoking its right to extend the period of time in which to file its statement of consideration, meaning that it will file its statement of consideration no later than September 15th, if memory serves, or it could be September 13th. I can't remember, but it would be, the Commission will be extending that deadline for those that are familiar with the regulation promulgation process. I think that covers some of the initial matters. This is for those that have not participated in this before. This is only my second one, so I'll just go by how we did it on the first time around. This is not sworn testimony, so once I call the party, if whomever is leading that party would like to make the introductions of the speakers, and then we will take it from there. I will be taking notes during this period of time, and I apologize in advance for any inadvertent hitting of the microphone while I turn pages. Before we start, are there any questions for me? Okay, great. So the first group that will speak come from Kentucky Power. Who will be speaking on behalf of Kentucky Power?
Mr. Penny, this is Eric Langley, and I'm an outside lawyer for Kentucky Power and for LG&E KU, and so I'll be speaking on behalf of both of them in this hearing.
Okay, and just for clarification purposes, Ms. Judd, will you, when LG&E and KU's time comes up, will there also be additional comments from Mr. LaFollette or Mr. Lovecamp?
No, certainly if you guys have any questions, those of us from inside the company are here. Mr. LaFollette, Mr. Lovecamp, and I wanted to be here in case there are any questions, but Mr. Langley will be making our prepared remarks. And if it's okay with you guys, I think he's going to plan to go ahead and make joint comments now on behalf of Kentucky Power, LG&E, and KU. And so we won't need to go later is what I'm saying to you.
All right.
That's okay.
That sounds good to me, Ms. Judd. Brevity is the soul of wit. I will call you all in the order in which it's listed, just in case you all do have anything to say. So, thank you. All right, well, Mr. Langley, the floor is yours.
Well, thank you, Mr. Penny, and good morning to everyone here. It's good to be with you all virtually, although I would much prefer to be with you in person. Just by way of reintroduction for those that don't know me, my name is Eric Langley. I'm an outside lawyer. I represent LG&E KU in this proceeding, as well as Kentucky Power. Most of my practice is actually devoted to these types of issues for a variety of investor-owned electric utilities across the country. So I'm familiar with most of the people on this hearing, not just from this proceeding, but from others as well. And Mr. Penny, you may recall that I participated on behalf of LG&E KU and Kentucky Power in the December and January public meetings on this topic, and I'm serving in the same role here today. Also, as you know, with me from LG&E KU is Sarah Judd. I believe John LaFollette is either on or is attempting to get on the call. Rick Lovecamp from LG&E KU also here, and Pam Ellis from Kentucky Power. So if there are specific data related questions that I can't answer, I believe that we have the people on the call that can answer those questions. As a preliminary matter, I want to express my appreciation on behalf of the companies that I represent for the Commission's attention to these very important matters. LG&E KU has a distribution network that includes more than 500,000 distribution poles with more than 270,000 third-party attachments. And that doesn't even include the poles that actually host ILAC attachments pursuant to joint use agreements. That's another 140,000 poles at issue there. For Kentucky Power, a little bit smaller of a network, but also a big one, 215,000 plus poles in Kentucky with more than 100,000 third-party attachments, again, not including the ILAC attachments, of which there are about 120,000 poles of Kentucky Powers that host ILAC attachments pursuant to joint use agreements, which is a topic we'll discuss in a bit. These rules that the Commission is promulgating have a pretty significant impact, both in terms of the cost to the companies that I represent and in terms of the operations, and in particular when it comes to matters of safety and reliability. And so that's sort of the cornerstone of the company's perspective when it comes to examining these rules and understanding the impact on the rules or of the rules on their networks. We also want to express our appreciation for the Commission's attention to the stakeholder input thus far, not just ours, but it's evident from the revised set of rules that was submitted to the LRC in mid-May that the Commission is really paying attention to what the parties are saying. We don't agree with everything in the rules, and I'm sure that the Kentucky Broadband Association doesn't agree with everything, and I'm sure that AT&T doesn't agree with everything. But it is noticeable that the Commission is paying attention to stakeholder input. And in particular, there's a couple of things that we were encouraged by that I wanted to point out before I get to some of the issues where we think there's opportunity for additional improvement. The first of those was the red tagged pole rule that the Commission adopted. We actually think that this is a well-balanced rule in that it puts on the pole owner the cost responsibility for poles that otherwise needed to have been replaced at the time of a make-ready pole replacement. We view this as vastly superior to the proposals that were put into the record by some other parties, including Kentucky Broadband, that would have shifted essentially 90% plus of make-ready costs to the electric utilities. So we're encouraged by what the Commission has done there. We're also encouraged by the Commission's adoption of the transfer provision in Section 6. And it wasn't exactly what the electric utilities asked for, but it was a good provision. And we think that it will go a long way towards solving one of the operational problems that utilities face in Kentucky and elsewhere, and that is the problem of double wood in the right-of-way and in electric easements. We're also encouraged that the Commission has saw clear to preserve the right of electric utilities to maintain their own distribution and construction standards rather than imposing the NESC as some sort of ceiling on electric distribution construction standards. And finally, we're encouraged by the movement that the Commission made with respect to the threshold number of poles in an application that triggers the obligation to negotiate in good faith for the timing and process associated with those applications. Now, as I'll discuss in a little more detail in a minute, we actually want that even lower, but I think that the move from 3,000 poles to 1,000 poles was definitely a move in the positive direction, and a move that was responsive to what we believe the record is showing here. Now, having said that, as I mentioned earlier, we do think that there are a few opportunities for improvement. And if I may, Mr. Penny, can I share my screen? Because I do have a few slides that I think will help with the...
Please do. If you can figure it out, then you're allowed to. Say, I'll ask, will these slides subsequently be, they don't have to be, but will they be sent will they be included in any written comments?
Well, I hadn't actually thought about that, but we certainly can submit them. Can everybody see my screen now? Or Mr. Penny, can you see my screen?
I can see them. There we go. That looks good.
Okay. Now, you'll have to forgive me, and everyone on the hearing will have to forgive me if I go too fast through the slides or hit the down button twice, because I do not consider myself an expert at PowerPoint. But I did think that organizing these thoughts with a few slides might help everyone understand what our main message is in this hearing. And so when it comes to the issues where we think there's opportunity for improvement, I've organized them into what I'm going to call Tier 1 issues and Tier 2 issues. And the Tier 1 issues are what I'll call the higher order, more conceptual issues that we would like to see further consideration of. And the Tier 2 issues are slightly more technical, but still involve a conceptual issue that I think is appropriate for a hearing like this. There will be a couple of other issues that are collectively referenced in the separate comments later to be filed by LG&E, KU, and Kentucky Power, but I would call those additional issues really more purely technical in nature. Excuse me. And so the first of the Tier 1 issues is the impact of the revised rules on joint use agreements. The second is the self-help remedy within the electric supply space. And the third is the red tag pole presumption in Rule 77B. And I want to make clear early and often that we support the red tag pole rule itself. It's just one of the presumption in that rule that we think needs some further work, and I will discuss that when we get there. The Tier 2 issues that I plan on discussing today are the impact of the rules on existing tariffs, the threshold number of poles in an application, which I mentioned earlier. It's moved from 3,000 to 1,000 before the good faith duty to negotiate is triggered. We're going to ask that be reduced to 300, and I'll explain why. The third issue is the 90-day cutoff for make-ready invoices. And the last issue that I plan to address today is the cost allocation for pre-existing violations. So that is a high-level outline of the topics that I'm intending to address. And even though there's not a set time limit. I intend to be respectful of the commission's time and everyone else's time, and to get through these things in as orderly a fashion as possible. There will be more fulsome comments submitted with our written submission. So the first issue that I want to discuss is the impact of these rules on joint use agreements. Now, by way of background, the joint use agreements are the specific agreements between electric utilities and what are now known as the incumbent local exchange carriers, but what used to just be known as the telephone companies. And these are the infrastructure cost sharing agreements under which telephone companies and electric utilities decided on a manner of sharing cost in the network and sharing space on each other's poles. These agreements saved both parties a bunch of time and a bunch of money, and spared the public the aesthetic nuisance and also the intrusions into the right-of-way from redundant networks of poles. But perhaps more importantly, these agreements were the foundation for the ubiquitous deployment of the first generation of communications infrastructure. And we think that that's an important point, because if one of the purposes of the rules is to promote broadband deployment, then we don't think rules that are undermining these joint use agreements, which were the original foundation for the deployment of communications infrastructure, is good policy. So the specific concerns about this issue really relate to two specific definitions. And actually, it all comes down to these two specific definitions within the proposed rule. The definitions are in section 1.2, broadband internet provider, and in section 111, telecommunications carrier. And these are the definitions as they appear in the proposed rules filed with the LRC back in mid-May. And we don't object to these definitions as far as it goes. The problem is how these definitions tie into the mandatory access provision in section 2.1. And so if we look at section 2.1, it extends a mandatory right of access to telecommunications carriers and broadband internet providers. If we go back to those definitions, it's plain to see that the telephone companies with whom electric utilities have joint use agreements likely qualify as broadband internet providers or telecommunications carriers. And what this does is it puts the telephone companies in the position of having a mandatory right of access to electric utility poles, but not vice versa. And given that the reciprocal right of access in the joint use agreements is pretty much the foundation of the consideration in the joint use agreements, it's easy to see how this is just the first step in really the unwinding of these joint use agreements and the unwinding of the agreements under which the first generation of communications infrastructure was deployed. And so the ask in this particular respect is simply that the commission use the language from section 1.9 in the definition of new attacher and put it in the definitions of broadband internet provider and telecommunications carrier. And the language that is highlighted on the slide that's up right now is the language that we would urge the commission also include in the definitions of broadband internet provider and telecommunications carrier, so that it clearly excludes a utility with an applicable joint use agreement. This would preserve that fundamental, that foundational consideration that is embodied within the joint use agreements. And this point about the non-reciprocal right of access that is seems to be created by virtue of Section 2.1's use of the terms broadband internet provider and telecommunications carrier is curious and perhaps even unintentional. And the reason I say that is because in the federal, I believe it's called the Federal Mandate Analysis Comparison, at the end of the set of rules that was filed with the LRC in mid-May, it actually lists the notable departures from how the FCC handles these issues. And it listed probably 5 or 6 different things. But one thing that it did not list was the extension of a mandatory right of access to ILEC attachments. And the reason that omission is itself notable is because the federal guidelines explicitly do not give incumbent local exchange carriers a mandatory right of access to electric utility poles. They are definitionally excluded. And the reason is because of the joint use agreements. And so given all of that, we think that there should be a similar exclusion within the rules that the commission is promulgating. So this impact on the joint use agreement flows through Section 2.1, which we've just discussed, but also through the tariff requirement in Section 3.1. Section 3.1. And in Section 3.1, it essentially would require utilities, which would include LG&E, KU, and Kentucky Power, to have a tariff that applied to pole attachments, which both of them do already. But that tariff would govern rates, terms, and conditions for pole attachments. Now, our language concern here is a little less clear because the term pole attachments is not separately defined, but the term attachments actually is. And so pole attachments in Section 3.1 is construed to mean the same thing as attachment in Section 1.1. Then again, it imports the definitions of telecommunications carrier and broadband internet provider in a way that on its face would make the tariff that LG&E, KU, and Kentucky Power file for applicability to cable television systems, CLECs, governmental entities, applicable to the ILECs, with whom they already have joint use agreements. And so between the access provision and this tariff requirement, these are 2 different ways that the joint use agreements are being undermined. But like the access requirement being non-reciprocal, the tariff requirement is non-reciprocal. And so what we're left here is essentially, what we're left with would be the ILECs have mandatory access, they're entitled to tariff rates, but not vice versa. We think that the right outcome here, for all of the reasons that we've set forth in our previous comments on this issue and the reasons that will be further articulated in the yet to be filed comments, that the joint use agreements ought to be excluded from these provisions. Now, one thing that is very important to remember in all of this discussion is that the joint use agreements have always been regulated by the commission. This is not a situation where these agreements were somehow negotiated without regulatory oversight and are therefore potentially the product of strong-arm negotiation, or that they are outmoded, or that they are anachronisms, because both parties have had the right at all times to seek relief from the commission. And in fact, that has happened in history. Various parties have sought relief from the commission under these agreements. So if, for example, an AT&T or a Windstream has an issue with a joint use agreement, they could have raised it 20 years ago. They could have raised it 15 years ago. They could have raised it 5 years ago. They could have raised it last year, but they didn't. These agreements, given that they have always been subject to commission jurisdiction, to commission oversight, to commission regulation, should be viewed as presumptively reasonable, which is yet another reason why any rules that undermine those agreements should be revised in our view. So the fix that we are proposing here, and this will kind of finish what I have to say about joint use agreements, is the simple one that I alluded to earlier. And it's just importing the language from section 1.9, which is the definition of new attacher, into the definitions of section 1.2 and into the definition of section 111, as I've set forth here on this slide. Okay, I'm going to move on to, whoops. Don't know how to temporarily take the slide down without losing the presentation, so just bear with me for a moment. The next issue I want to talk about is the self-help remedy in the electric supply space. The Commission's proposed rule, as it currently stands, would give an attaching entity the right to hire a contractor to perform make-ready in the electric supply space if an electric utility missed its make-ready deadline. And just at a very high level, we don't think that's good policy really under any circumstance, but particularly not when viewed through the lens of a risk-benefit analysis. I mean, I think it goes without saying that electric supply space make-ready carries higher stakes. The work is often more complicated, and when there are mistakes, it can lead to far more significant consequences, outages, serious injuries, even fatalities, unfortunately. And here in Kentucky, there isn't any evidence in the record that would suggest that electric utility make-ready in the electric utility supply space is the cause of any kind of broadband deployment. I mean, I'm not even sure that that's been alleged in the record, let alone demonstrated with any kind of evidence. And so while it's at least conceptually possible that this remedy would be appropriate somewhere else, for all it appears, there is no evidence that it's appropriate in Kentucky. It's also important to understand what kind of make-ready the Commission's proposed remedy would actually touch. And in Kentucky Power's initial comments, it actually submitted data showing that really a very small fraction of poles required electric supply space make-ready at all. And I think that data was showing that only about 17% of poles, make-ready poles, required that type of make-ready. Well, Kentucky Power was able to distill that data even further, and this will appear in the written comments that we'll be submitting shortly hereafter, and isolate the type of make-ready that would actually be impacted by the rule that the Commission is proposing. In other words, the data that Kentucky Power previously submitted was over-inclusive in that it also captured pole replacements, which of course are not part of the Commission's rule. And so what we're seeing here is that just a very, very small slice of the poles that people are applying to attach to would even be eligible for the supply space self-help remedy that the Commission is proposing. In 2019 and 2020, there were roughly 2,200 poles to which entities sought to attach, and less than 5%, well under 5% of those poles would have even been eligible for the type of self-help remedy that the commission is proposing here. Now, importantly, we're not saying that individual utilities should be discouraged from implementing their own programs, which under strict protocols can cede some of this control during a major deployment. But such a decision should be left in the sound judgment and individual discretion of a particular utility. And LG&E KU is a great example because as the commission is probably aware, LG&E KU's pole attachment tariff has actually included a version of this since 2016. But it's been on very strict terms and conditions, very strict protective protocols, and in LG&E KU's discretion. And so while we think that utilities, that there's nothing wrong with encouraging utilities to adopt this, we don't think that it should become a matter of regulatory right through the rule, because then that it eliminates the ability of the particular utility to implement the types of controls that we believe are necessary for this very sensitive type of work in the electric supply space. And so in sum, on this particular issue, we think that the electric supply space self-help remedy is a solution in search of a problem. There just isn't a demonstrated case for the need. There's no showing that electric utilities are a source of broadband delay, and then balancing those against what I think everyone will agree is a pretty sensitive area for make-ready. We just don't think that this is the right solution. And incidentally, this whole concept of self-help make-ready in the supply space is still very, very new. I mean, even the FCC didn't allow this until the 2018 order, and there's still a predominance of state jurisdictions which have no provision for supply space self-help make-ready. Right, the next and the final of the Tier 1 issues that I wanted to address deals with the red-tagged pole presumption. And again, I want to express our appreciation for the balanced rule that the Commission actually adopted here, in that if an attacher applies to attach to a pole, and it turns out that pole had already been flagged for replacement pursuant to the inspections that the utilities conduct on a 2-year cycle pursuant to administrative reg, that cost responsibility falls on the utility. LG&E KU and Kentucky Power have no problem with that. In fact, that has already been their practice. The concern that we have with the red tag pole rule relates exclusively to the presumption in 7B, and in particularly with respect to the highlighted language in subpart 2. And we may be overinterpreting this language, I'll concede, but I think that our skepticism is warranted, given that there have been some efforts to shift significant costs to the electric utilities during the make-ready process. And so the best way to characterize our concern here is that we don't want to have to produce a clean bill of health for a particular pole to overcome the presumption in 7.7b, because that is not the way that inspections are conducted pursuant to 807 KAR 5006. And 807 KAR 5006 is actually referenced in the rule as as sort of the foundational inspections for this rule. And I want to walk through the way that information is collected and the types of information that is collected, as well as the type of information that is not collected, to help explain our point a little bit more. As an initial matter, there's been no contention, and I don't think that anyone would suggest it's the case that LG&E, KU, and Kentucky Power are not following the regulatory requirements. In fact, LG&E, KU, and Kentucky Power firmly believe that they are in full compliance with 807 KAR 5006. But the way that these inspections are conducted is on a circuit-by-circuit basis. And by the way, these inspections are looking at things beyond just the poles. I mean, they're inspecting distribution equipment as well. And so there's a lot of things that the inspector is observing during these inspections, and deficiencies are actually noted by exception. So when there is a problem, whether it's a pole or whether it's a conductor or whether it's a switch or whether it's a transformer or anything else, they note the exception on the circuit map. And so here is an example of an LG&E KU circuit map inspection. This is actually it's an inspection performed, I believe, last March. And the red line shows the circuit that was inspected. And if you can see the yellow circles on there and the highlighter, those are the exceptions noted in the inspection. And those are the locations for which a record would be created. But all the other poles and all the other equipment along the red line circuit inspection, there's not a separate record for each of those poles created that says, yep, this one's good. And let me bring some further color to that. So this is the inspection report form that was generated as part of the circuit inspection that we just saw. And you'll note at the bottom that it identifies the two particular locations where a deficiency was noted on that circuit. And after those deficiencies are noted, there is a construction work order created. And so here we see the construction work order for one of the poles that was specifically referenced in that last reporting form, and this happens to have been a pole changeout. This is how records are created and maintained by the utilities pursuant to these inspections. And so if there's a pole that was inspected on this circuit that was just fine during the inspection, there's no record that the utilities can produce to demonstrate that other than this map and the deficiencies. And so, as I said earlier, we may be overinterpreting this, but we want the one of two things here, either for the presumption to be deleted or in its entirety, or at a minimum for the commission to make clear that the inspections that the utilities are performing in compliance with 807 KAR 5006 are sufficient to rebut the presumption. Because the last thing that we want is for one of these poles on the red line that we're looking at right now to somehow, by lack of a specific record relating to that specific pole, be put on us as a make-ready cost responsibility.
And I will say, I think that the intent by adding that language was to just ensure that the utility was following the inspection regulation, not to put any additional duties onto that. But we will take a look at your proposed language.
Okay, well that's good to hear, and thank you for saying that. So that concludes what I'm identifying as the Tier 1 issues, and I want to move now to the Tier 2 issues, and this will not take as much time. I want to start with the impact on existing tariffs. And again, I wish I could take this down and put it back up with ease, but it's revealing the limitations of my PowerPoint and GoToMeeting prowess. Uh, so let me go back. Here, there we go. The first issue among the tier 2 issues that I intended to address was the impact on existing tariffs. Section 3 requires that pole owners submit tariffs that comply with the new rules. And this is certainly an issue for both LG&E, KU, and Kentucky Power, but particularly for LG&E, KU, because LG&E, KU has a pretty comprehensive tariff that addresses virtually all facets of the attachment relationship and attachment process. And the tariff in its existing form or substantially similar form was first submitted in 2016, went through stakeholder intervention, commission review, and was approved. That same process unfolded again in 2018. And there was stakeholder intervention, commission approval. And then a very similar tariff was submitted in 2020 in connection with the rate case. And though I don't think there was any stakeholder intervention in that proceeding, it too was ultimately approved. And so LG&E KU's tariff, which does have some provisions that would conflict with the rules as proposed by the commission, has already been vetted through 3 separate proceedings, all of which either actually involved stakeholder input or could have involved stakeholder input. And in fact, the tariff in many places reflects some of that stakeholder input because of the negotiations that occurred after, for example, KBCA, or rather its predecessor, I think, KCTA, and Charter intervened to express some concerns about various provisions. And so I guess to put a finer point on the concern here is if these terms and conditions have now been vetted through 3 separate proceedings in the past 5 years, why is it that they are somehow, by operation of the new rules, going to be viewed as out of compliance? And so what we would like to see here is an opportunity for terms and conditions that are already in existing tariffs to take precedence over the rules. Now, this same concern doesn't exist for Kentucky Power to the same degree it exists for LG&E KU, because in many respects, Kentucky Power's tariff is leaner. It doesn't have the same comprehensive type of provisions. But one specific application here, and this is not the only issue that I think LG&E KU would say needs to be preserved, but one very specific one is the threshold number of poles in an application before there has to be some sort of separate negotiation for the timing and process. And so when LG&E KU submitted the tariff as it exists in substantially similar form to the one that's there now, first in 2016, it actually included this high volume deployment plan. And what it said is that, all right, once we're dealing with more than 300 poles in a month, then there needs to be a separate negotiation for the timing and process. And nobody has objected to that. I mean, nobody objected in 2016. Nobody objected in 2018. Nobody objected in 2020. And in fact, it's not like people were just totally asleep at the wheel either, because we've actually had, we meaning LG&E KU, have had 2 entities that have reached out and have entered into these high volume deployment plans for major deployments. And those special contracts have actually been filed with the commission. So we think that there's a really good track record of that process working. So not only is that an example of one of the terms and conditions that's been fully vetted 3 separate times in the past 5 years that we think ought to be preserved, but we also think that that should possibly even be reflected in the rule itself, given the history of this issue. To say nothing of the fact that we have yet, and by we I'm specifically referring to LG&E KU right now because they've had a good bit of experience with high volume deployments, have yet to see someone actually be able to deploy the numbers that they would like. And it's not because of us, it's because they can't corral the resources. And so the electric utility processing of the applications is not the issue with these deployments. And the duty to negotiate after 300 polls really also presents the opportunity for the solution to be narrowly tailored to the specific type of deployment. Because there's a difference between doing one big deployment in a relatively urbanized area versus a deployment that is in separate parts of the state in rural areas. And so those differences would seem to counsel in favor of tailored approaches which work for the benefit not just of the parties, but also of the people who stand to benefit from broadband deployment. All right, the next issue, I'm going to scroll down here in my slides. The next issue has to do with an addition the commission made between the originally proposed rules from I think February of 2020 versus the version that was filed with the LRC in mid-May. And it's this limitation on the reasonable period after completion of work by which a final make-ready invoice must be sent. And this probably seems like inside baseball, super technical, but it's not. And there are some specific reasons why. This is, I think that LG&E KU and Kentucky Power would like to see more flexibility with this rule. And if there has to be a deadline at all, we think that should probably be 180 days. But let me use for just a moment Kentucky Power as the example for why this 90-day time period, even though it seems like it's a good bit of time, is not sufficient. So currently for Kentucky Power, it isn't an issue because Kentucky Power bills on work order costs. And so whatever the work order generates, if it's $1,250 for a make-ready job, that's what the attacher pays, and there's not a true-up. Well, Kentucky Power is moving to billing a true-up so as to ensure that those costs are all properly allocated. And the job itself, the work order, doesn't even close until 60 days after completion of the work, so that whatever contract resources may have been leveraged on a particular project, and this isn't just in the make-ready context, this is more broadly just in the electric supply context, that 60-day period after the job is completed allows contract resources, allows internal resources to submit their invoices or to attribute their time and materials to a particular project. All right, so that's 60 days. Then after that, there's a reconciliation process, and then only after that would there be billing. And we think that reconciliation and billing process itself is probably about a 90-day period. So even with those two markers, the 60-day period and the 90-day period, we're already up to 150 days. And that provides minimal, if any, flexibility. And so we think that period ought to be 180. We don't think that will prejudice attaching entities. And it's certainly 180 days would not be abnormal for this type of process. All right, the last of the issues that I intend to address, and now I will try to close out my there. Are y'all still with me? Okay, excellent. The last of the issues that I wanted to address is the cost allocation for pre-existing violations. Excuse me. And this is an issue that arises in the context of Section 46B. And 46B, as far as it goes, we think is a proper expression of fair cost allocation principles, which is that attaching entities that didn't cause a violation shouldn't be charged for it. So our concern on this issue has more to do with what is not in the rule versus what is in the rule. And what's not in the rule is a similar statement that the poll owner, unless they were the cause of the violation, should similarly not be charged with the cost of that pre-existing violation. So the rule we think ought to include a combination of some or all of the following. Either a clear statement that the poll owner similarly is not responsible for pre-existing violations that it did not cause, or perhaps if the goal here is to expedite broadband deployment, to give the attaching entity the right to fix that violation or to pay someone to fix that violation, but then to be able to pursue the cost causer. Or third, and this will all be in our written comments, or third, perhaps adopt a default rule similar to the rule adopted by the Louisiana Public Service Commission, which in instances where it cannot be reasonably determined who caused the violation, and that is actually quite frequently the case, that it's allocated equally among the existing attachers to the poll. But this is the type of thing that can really mire broadband deployments, because an electric utility does not want to be in the position of the creditor for the broadband deployment. Because while it's tempting to say, well, why can't the electric utility just pay for this and then go after the cost causer? That's like, again, putting the electric utility in the position of creditor and then having to pursue the cost causer after the evidence has been spoliated, to use a legal term, after the whole thing has been corrected so that the broadband deployment can pursue. And given that the electric utility poll owner, in that instance, assuming they were not a cause of the violation, stands the least to gain in that instance, we think that they are the last person or the last entity on whom that cost should fall. Well, as I mentioned at the outset of my remarks, these rules, though they seem in the weeds because it's poll attachments, they have a pretty significant impact on the financial, operational, safety, reliability aspects of our electric distribution systems. Again, we appreciate the Commission's attention to these very important matters. We appreciate the opportunity to offer this additional feedback. And as I referenced earlier, LG&E, KU, and Kentucky Power will each be submitting separate sets of comments that more fully address the issues that I've previewed here. And collectively, there'll probably be 2 or 3 additional issues that are raised in those comments that I would call I would say are more technical in nature, but they will certainly address the ones that I've discussed here. So, Mr. Penning, unless you or if there are other commissioners or commission staff on the hearing have questions, that concludes my remarks, and thank you for your time.
All right, thank you, Mr. Langley. I do not have any follow-up questions on this, and I don't know if any other staff is on the call at this time. I don't think we anticipated them being there. Unless anybody else from Kentucky Power or KU or an LG&E have comments, we can move on to Duke Energy. And so Ms. Honaker or Mr. Gibson or Mr. Freeburn, the floor is yours.
Yes, thank you very much. Good morning. My name is Scott Freeburn. I'll be representing Duke this morning. I'm the manager of joint use for Duke Energy, which includes Kentucky, northern part of Kentucky, Cincinnati, southern part of Ohio, most of Indiana, North Carolina, South Carolina, and Florida. And we are responsible for joint use governance, which includes the permitting of third-party attachments on our poles. So having said that, I'd just like to jump into it. There are 5 different sections of the proposed that we would like to comment on today for consideration or further clarification. So Mr. Langley did a very good job of surmising some of the things that we will review today, and I'll just try to hit those high points on those items. So to start, over in section 4-C, it requires the utility to share the contact information of each and every attacher on a pole and all notices previously provided. So this requirement, we feel, is overbroad and unduly burdensome for a utility. So in the Midwest and in Kentucky, currently Duke Energy utilizes an electronic notification system to notify current attachers, the originating proposal number, and the company of the new attacher, so they can cross-reference it. We feel that the company should not be required to provide the contact information of all notices sent to the existing attachers. We don't do it in any other state. We feel this would be a pretty big administrative burden to keep current contact information of every attacher that we have. So we recommend that the proposal be reviewed for consideration and eliminated. We would ultimately like to see it. The second point is around contractors for survey and make ready. And again, Eric hit this pretty hard. So we feel the regulation as drafted permits new and existing attachers to request the addition of any contractor be added to the utilities list of authorized contractors to perform work on its electric poles. So Duke and other electric utilities, we typically have approved list of qualified contractors, for that reason. We want to make sure that if they're working in the power space, they do it with the right personnel. These utility-approved contractors have the required training and knowledge to access utility poles in a manner that complies with applicable safety regulations. There's been too many times the companies had to deal with third parties accessing utility poles with improperly qualified personnel without the knowledge of the utility. These unqualified contractors are not familiar with OSHA administration regulations working in the power space, and they can present a risk to themselves and system reliability. The next part, and this is really for, we just want clarification around this. It was a little vague, but we want to make sure that it's covered. And this was around transmission poles, and we feel they should be excluded under the definition. So currently, Duke Energy requests that transmission poles be specifically excluded from the Commission's proposed regulation. Although Duke, Kentucky appreciates the Commission's comments in the regulatory impact analysis and tiering statement section at the end of the regulation, requiring utilities to exclude transmission poles in the utilities tariff then shifts the burden onto the utility to prove why transmission poles should be excluded from attachments in the service territory. We feel that transmission poles are inherently different than distribution poles. Most transmission structures are not designed to accommodate additional attachments. When this happens, there will be integrity issues due to excessive loading that becomes problematic in ice and wind loading situations. Transmission poles are the backbone of system reliability, and any additional attachments on transmission structures should be met with great caution. Moving on to the right of access, which Eric also touched on. So the proposed rules prevent telephone and electric utilities from using the new access and make-ready provision. And this was done through the definitions in the new attacher section, which excludes a utility utilizing a joint use agreement. The proposed rules do not include similar language in their definitions of broadband internet provider and telecommunications carrier. Because telephone companies provide broadband, they would likely fit into each of those definitions. The new rules provide a mandatory right of access to broadband and telecommunications carriers, but they do not provide similar right of access to the electric utilities. The proposed rules imply that telephone companies with non-reciprocal right of access on electric utility poles. So under this rule, electric utilities could be denied access to telephone poles. It could not deny access to the telephone companies. And the last part I wanted to touch on was, also Eric touched on, was the work order true-up in accounting. When utilities provide work orders for new attachment construction, they're based on a generated estimate. So all work is completed and inspected for compliance, and an accounting true-up of the estimate may be necessary to determine actual costs, so refunds or additional charges may be billed. Under the new proposed guidelines, the utility would only have 90 days to complete the true-ups. Typically, this process can take up to 180 days to close out all project-associated work orders and access the actual cost. Limiting the time for accounting to gather project cost, billing, and applying credits would decrease the utility's ability to determine actual cost. So in closing, I want to thank the Commission for the opportunity to provide the comments to the proposed revisions and new administrative rules, and respectfully request the Commission consider and adopt Duke's comments. Thank you.
Thank you very much. Does anybody else from Duke Energy wish to speak? Okay. Well, there being none, I will give the floor to AT&T Kentucky.
Good morning, Mr. Penny and participants. This is Dan Reinhardt with AT&T. I'm Director of Regulatory for the company. On the call today with me is Mark Peters, Area Manager of Regulatory Relations, and John Tyler, our counsel. I'll be addressing a number of issues that we have with the rules as written. And similar to Kentucky Power and KULGE, we will be looking at the issues we have in two basic buckets. The first is the areas that are of most concern to AT&T and stand out significantly to us. And then there are a series of what we would term miscellaneous issues that we believe could and should be addressed by the Commission. So our first issue is that we believe that as the rules are drafted presently, they fail to actually comply with the statutory mandate from House Bill 320. House Bill 320 set up a paradigm where cooperative power companies can actually enter into and be competitors with broadband service providers, and that clearly puts them in the position of entering competition with AT&T, an attacher on their poles. We're concerned that the power companies, not only the cooperatives, but investor-owned utilities, setting up their own broadband affiliates or utilizing assets that they attach to their poles at preferential prices could disadvantage AT&T. And relative to that, we believe that in terms of House Bill 320, The language of House Bill 320 suggests that the Commission adopt rules for pole attachments for broadband providers. It was not exclusive to power companies. It was not exclusive to cable companies. It was not exclusive to wireless companies. And it certainly did not exclude incumbent local exchange carriers like AT&T. And we also look at historic statements by the Commission. In the 2004 case of Ballard and Jackson Purchase, decided in August of 2007, the Commission clearly recognized that there are specific concerns that should be addressed. It recognized the statutory requirement in KRS 278-170 that as to rates, no utility should give an unreasonable preference advantage to any other. And that would also, in our view, contemplate joint use agreements. So we basically believe that the rules should not carve out any kind of distinction for rates applicable to any broadband service provider with pole attachments, and that would include AT&T as a joint user through joint use agreements. So AT&T would propose two modifications, and let's see if I can share the document here in a moment. And we would propose that there be two modifications to the rules to address this, and namely in definitions, paragraph 9, new attacher, the express exclusion of joint use agreements from the rule should be stricken. And in section 3, relating to pole attachment tariffs, that section of the rule requires a compliance tariff be filed by pole owners with attachment tariffs. We don't disagree that joint use agreements are useful, but we do believe that the pricing in those agreements is unjust and unreasonable. We believe this is an excellent opportunity for the Commission to clarify that very thing and invite through compliance filings joint use parties to overtly affirm their existing joint use agreements and conform pricing to the requirements of the Commission.
So with regard to the joint use agreements, were you listening earlier to Mr. Langley's discussion and the electric utilities concerns with regard to the joint use agreements, or how the definitions might give the telephone companies unlimited access to the electric poles but not have a corresponding, or it might somehow limit the electric utilities access to telephone poles under joint use agreements?
Yes, Mr. Penny, I did hear that, and AT&T would be open to a modification here that would require a reciprocal requirement for the telephone companies to allow power companies to be on the poles. It's not an issue for us. In fact, we've not had issues with allowing power companies onto our poles. And so there's, as far as we're concerned, there's not an issue to be addressed.
Okay, and so, but you obviously do not speak for all incumbents, but
that's correct.
Okay.
But AT&T has no issues with power companies having a statute or having a right of access, whether it's through the rule or whether it might be interpreted from the current statute. And in fact, if you look at House Bill 320. The power companies themselves, through affiliates, you have to look to see the exact language in House Bill 320, but House Bill 320 seems to imply that power companies ought to have access to pole attachments on poles. I don't believe that the House Bill 320 does anything to preclude the requirements of itself applying to telecom pole owners.
Okay, and so the issues, and maybe you're going to get to this, so I do apologize for interrupting. But so the issue that AT&T has, and forgive me if I'm mischaracterizing this, is not with the issue AT&T Kentucky has with regard to joint use agreements is not the existence of the joint use agreements, but it might be the pricing that's currently included in joint use agreements.
Yes, Mr. Penny, that's substantively it. When we compare joint use pricing to tariff pricing, we're often seeing that the joint use pricing is multiples of the tariff pricing. And in the Ballard-Jackson purchase decision, the Commission clearly understood from the evidence in that case, even though the Commission said this case applies only to Ballard-Jackson purchase, it still promulgated or still identified core principles. Those principles were that an attachment by an electric or by a telecommunications company on an electric pole is functionally no different from the attachment of a cable company on an electric pole. And from that, it's a similar service, or it's an identical service provided similarly. There's no reason that the pricing ought to be distinct unless agreed to by the parties.
All right. Very well. Thank you. I apologize for interrupting. If you can
No
find your train of
problem.
thought, go ahead and follow it.
Okay. The second area of significant concern to AT&T really ties in with the access of telecommunications carriers to electric company poles, whether or not they have a joint use agreement at reasonable rates. That second area is the establishment of rates themselves. The Commission has long-standing procedural rules from the 1980s that have been applied, but there have been significant changes since the 1980s when the administrative rule was last looked at. The FCC has gone through a variety of evaluations of its statutory requirements. It's evaluated those, it's made rules, and those rules have stood challenges by the electric companies, including the owners of Kentucky Power, Kentucky Utilities, and LG&E, all the way to the Supreme Court, that have upheld the pricing standards approved by the FCC. And there are substantive assumptions that go into that. There's some similarity to the administrative rules, but we believe that since the FCC's rules have withstood challenges all the way to the Supreme Court, and it has been, and the administrative rules of the Commission were adopted even before the Telecommunications Act of 1996, before there were competitive local exchange carriers, et cetera, that adoption of FCC rules would be appropriate. And in order to keep those rules consistent over time, we would also propose a section, as we have in our filed comments, that would allow continuous updating, so that if, for instance, power companies were to prevail in some instance related to some term, condition, or directive in the pricing of pole attachments, that they could benefit from the changes in FCC regulations once those regulations go into effect. So we make some proposals. We make a proposal to insert a new section 7 just before the end of the rules called rates, and it defines what rules would be followed from the FCC.
And
So our third and final
well, I'm sorry, I have
Was there a question?
a question to clarify. I'm looking at the language right now. And
Yes, sir.
so it says, I think, section 2, changes in effective and applicable FCC rate regulations shall be deemed to take effect under this regulation 90 days after the effective date of the FCC rules. So under that scenario, would it be incumbent upon the pole owners to then file new rates under whatever new rate regulation has been finalized at the FCC? Meaning that would they have
Good
to file,
question.
would they have to file new tariffs, new tariff sheets with the commission?
That is the concept, or at least it could be enforceable. AT&T, for example, evaluates its costs annually and refiles its prices with the commission once a year.
You mean, by commission, by the commission, you mean FCC?
I'm sorry, we actually filed with the Kentucky Commission.
Oh, okay.
On an annual basis. And we do file on an annual basis in jurisdictions that require tariffs. And we do update our pricing in every other state with or without tariffs on an annual basis. So, and AT&T has, in fact, followed FCC guidance in making its attachment rates conform to statute and regulation on a regular basis. For example, in 2011, the FCC adopted a modification to the rule for the rate development for cable TV companies, and it is the law of the land. And AT&T modified its rates in most jurisdictions after 2011. So I would suggest, Mr. Penny, that it would be applicable in terms of any normal tariff filing schedule that a pole owner had.
Okay. All right. Thank you.
All right. Our third area of concern relates to a comment that we made in our first rounds, and that was relative to collective bargaining agreements. We believe that the commission rules should allow for collective bargaining agreements. It is a contractual obligation we have with our unionized workforce to do particular work, and that to some extent, without the recognition of those contracts, we believe the rules could violate our contracts and put AT&T in a substantial difficulty with the union for a number of reasons. So those are the major issues. And I'll pause for a moment, see if there are any questions, and then I can move on to the miscellaneous issues.
Let me take a quick look at the proposed language you have with regard to the One Touch Make Ready collective bargaining. I don't believe I have any questions. Thank you.
Thank you very much. We have half a dozen of related miscellaneous issues. We propose, because the terms are used throughout the rules but are not defined, we propose the addition of definitions for a standard contract, a special contract, and a joint use agreement. Again, we would consider a joint use agreement simply to be a particular type of special contract between two entities with poles, and specifying the rates, terms, and conditions of that joint use. But in essence, it is a subset of special contracts. The additional area, next area, is in section 2 of the rules. we felt that the limitation on outdoor lighting was a little over restrictive, and suggest that the commission narrow the rule to decorative lighting poles that are typically not associated with pole attachments, but we would leave any outdoor lighting that is based on a wood pole to be included in the possibility for attachment. In section 3, subsections 4 and 5, we suggest that and we have seen instances where power companies will adopt in-house, homegrown, very restrictive engineering practices to the place where it causes difficulty with the deployment of services. And so we suggest that we insert in the subsection 3, subsections 4, or section 3, subsections 4 and 5, a limitation on engineering standards to be those that are generally applicable. We don't specify any ESC, but we do say generally applicable so that it's not overly restrictive.
Never mind. Go ahead.
Okay. We find ourselves in agreement with Kentucky Power and the other power companies on make-ready invoicing. Our view, AT&T's process is such that an attacher asks for make-ready work, and we give the attacher a full year to actually implement their attachment. They can obviously do it before that, but we give them a full year to do it. And we hold a job open for that whole period. We basically then do our post-installation inspection, and after that point, we do our invoicing. So we suggest modifications to change the due date for invoicing for make-ready. In section 4, subsection 10A3D, there's an ambiguity relative to what happens once a make-ready job is determined to be complex. We believe it should be enforced a bit more to specifically say that the job on poles that are deemed to have complex make-ready, that work should stop until it's should basically stop as one-touch make-ready work. Similarly, in section 5, subsection 4, we suggest that there's on make-ready classification. The language currently says that a consulting representative of an electric utility can make a determination about whether or not that job is simple or complex. We don't believe consulting representative is necessary language. So at a minimum, we would take that out. We would probably suggest removing the whole section as it's duplicative of section 2(1)A.
So the alternative proposal, never mind, I'm probably stealing your thunder. Go ahead.
No, go ahead.
I'm just saying, I'm looking at the alternative proposal to remove from section 5, sub 4, you just remove consulting representative of an electric utility. So just say a utility may make final determinations, et cetera, and so forth.
Yes.
Okay, so what's the basis for removing that?
It would seem the language implies that it's only a consulting representative of the company. It could be a third party. It doesn't overtly say that it's going to be the utility itself. Taking that out doesn't remove the possibility that the utility through a hired intermediary can make that decision. But the language of consulting representative there seems to limit it to being a consulting representative.
Okay.
All right. On section 363A, we suggest that transfers in the instance covered by that section, electronic transfer, electronic notice would be a useful thing to add. In section 63D, we're concerned that utility owners may simply choose to do transfers early and send us the bill. So we would prefer to take section 63D out. The issue here is that the section doesn't truly limit itself to, while it does limit itself for safety and reliability purposes, it doesn't actually limit it to accident or natural disaster, that sort of thing. We find ourselves also in agreement with Kentucky Power, largely on the issue of red tag poles. There's a burden of proof issue here. We believe that the section should come out. This is section 7B, because the opportunity for inspection and review of the poles to be worked on through make ready and or replaced can be done at the field visit between the utility and the new attacher. Finally, the very last one is at the very end of the rule regarding complaints. The current language is written narrowly in that a complaint can allege that a person or entity was unlawfully denied access to a pole, duct, conduit, or right of way, but it doesn't overtly include unlawful rates. So we encourage the commission to incorporate a few more words here to overtly include rate complaints in the list. And Mr. Penny, that concludes my presentation.
Okay, thank you very much, and I will also extend my thanks to AT&T Kentucky for finding some of my typographical errors in what I've submitted to the LRC. So I do appreciate that. It might save me a little bit of time. All right.
Thank you, sir.
All right. So I don't believe Kentucky Utilities and LG&E they've already had their piece, but just to confirm, does anybody from KU or LG&E want to speak? All right. I'll take that as a negative. Does anybody require a break? I do not, but I understand that you all may have been tethered to your computers for a while. So let me know if you all want a 10-minute break or so. Like I said, I don't require it, but I'm happy to indulge. I'll give you a few seconds to find the unmute button if you do need a break. Okay. I'll take silence as assent. So we will move on to the Kentucky Broadband and Cable Association. Good morning, everybody. It's your all's floor.
Thank you. This is Jim Gardner. I'm an attorney representing the Kentucky Broadband and Cable Association. With us today are Jason Keller, who's Vice President of Government Affairs, Paul Werner, partner with the law firm Shepherd and Mullen, Patricia Crabton, consultant. Those three folks will give the opening presentation on behalf of the Kentucky Broadband and Cable Association. Also here to be available to answer questions are Jill Ballenstein, Vice President Legal for Charter, and Dan Gonzalez, who's State Regulatory Affairs. With that, I'll turn it over to Mr. Keller.
Thank you, Jim, and good morning. I'm Jason Keller, as Jim noted. In addition to my role with Charter Communications, I also serve as board chairman of the Kentucky Broadband and Cable Association. And on behalf of our member companies, I want to thank the commission, Mr. Penny, Ben Bellamy, and others who have spent and invested many, many hours on these important regulations. When the commission launched this process more than a year and a half ago, our company knew at that time how important clear, effective regulations would be to help advance broadband deployment in Kentucky. But I'm not sure any of us knew just how important these rules would become to ensuring Kentuckians, and particularly those in rural areas of our Commonwealth, have access to reliable broadband service. Since this process started, we've experienced a pandemic that highlighted the importance of broadband access. The Kentucky General Assembly appropriated $300 million in funds to support broadband expansion and incentivized at least another $300 million matching dollars from broadband providers. The federal government appropriated $148 million, the Rural Digital Opportunity Fund, to build broadband to unserved areas. Kentucky's local governments have received $1.2 billion in funds from the American Rescue Plan, and many of them are evaluating using significant portions of those dollars on broadband. And cable operators are stepping up as well. I'm proud that my company has committed to an additional investment of over $100 million in Kentucky to bring broadband to those who don't have it. Deploying broadband has never received more focus and attention from policymakers and the public at large. And now we have to build the networks and extend service. And providers like those represented by the Kentucky Broadband and Cable Association must largely utilize utility poles to expand service. As a result, these regulations can mean the difference between getting broadband built quickly or seeing projects bogged down for years through make-ready and permitting delays. And that's a perspective shared not just by cable operators, Kentucky businesses, large and small, and organizations that support businesses across the Commonwealth, like the Associated Builders and Contractors. And Big Ass Fans have voiced clear support for effective pole attachment regulations. Educational organizations and coalitions that support Kentucky's children, like Teach for America Appalachia, Kentucky Youth Advocates, and Advance Kentucky, have voiced support for fair, equitable pole replacement rules. Organizations that support Kentucky's doctors, like the Kentucky Academy for Family Physicians, have likewise voiced support for pole rules that facilitate expanded broadband access. And their support echoes comments made by state leaders like State Senate President Robert Stivers, who wrote, and I quote, "This proceeding is an opportunity to streamline access to the critical infrastructure needed to expand service to rural areas of Kentucky. This includes effectively addressing pole replacement issues and make-ready processes, which can enable broadband providers to build out their networks more efficiently and effectively," end quote. And also local leaders like Scott County Judge Executive Jill Pat Covington, who has also written, quote, "One of the biggest barriers to rural expansion is the cost associated with replacing utility poles. The current PSC proceeding could fix this by ensuring fair and predictable pole replacement costs, helping to expedite broadband deployment in a much more cost-effective way," end quote. Quite literally, thousands of Kentuckians have taken action to convey their support for strong, fair pole attachment rules, because they recognize the need to expand broadband farther, faster across our rural areas. Our association greatly appreciates the steps the commission has taken so far, addressing issues like make-ready timelines and one-touch make-ready practices, which the proposed regulations accomplish, will make a meaningful difference. However, as Paul Werner and Patricia Crafton will detail, we encourage the commission to take additional steps to more fully address critical issues like pole replacement and the long-standing practice of overlap. Again, thank you, Mr. Penny and the commission, for your work on this issue. We know these regulations hold the promise of making a real difference in the lives of thousands of Kentucky families and businesses. Paul.
All right, thank you very much. And before Mr. Warner starts to speak, I would like to remind everybody to please mute your computer unless you're speaking, because we do get a little bit of feedback with when somebody has their microphone on. But Mr. Keller, thank you very much for your comments. I appreciate them. Mr. Warner?
Good morning, and thank you, Jason, and to see everyone here gathered on the important topic of pole attachments again. We really have the opportunity to sit with the commission today on its proposed pole attachment regulations. As we see it, the regulations are really a positive step forward to promote the deployment of broadband services that carry massive economic and social value for Kentuckians, by ensuring that providers have access to essential pole facilities on reasonable rates, terms, and conditions. The KBCA has already submitted comments on this latest round of proposed regulations, and we propose discrete ways to strengthen the regulations so providers can quickly, efficiently, and cost-effectively deploy their networks and deliver the promise of broadband to customers in Kentucky. I'd like to just briefly touch on the key points of our comments. First, with its treatment of replacement costs for so-called red tag poles, the Commission has clearly recognized that attachers should only bear costs that utilities incur because of the provider's attachments. That is the cost that the attachers themselves actually cause. But that issue and that policy apply to other pole replacements too, not just red tag poles. And so we request the Commission extend the same rationale to other poles to ensure that pole replacement costs are equitably and properly allocated. As Patricia Crafton, whose report we submitted with our comments, will discuss next, pole owners benefit from replaced poles. Even if the poles would not qualify as red tag poles, requiring pole attachers to bear a disproportionate share of pole replacement costs will lead to delayed and canceled investment in rural broadband with attendant economic and social welfare losses. So we request the Commission to amend its regulations so attachers are only responsible for the remaining undepreciated costs of any prematurely retired poles. Second, with respect to overlashing. Overlashing is a common and long-standing practice that's critical for timely and efficient network deployment, and we appreciate that the Commission has taken steps to ensure that attachers can continue to rely on it. But again, we request the Commission to go further than it has in its proposed regulations and actually adopt the FCC's notice-only approach as we propose in red lines of the regulations that we submitted with our comments. The FCC has found the practice safe and effective, given that it only involves the addition of additional lightweight fiber optic cables to existing mainline attachments. And the practice is supported by the utilities themselves. There's no question that overlashing carries real benefits for consumers. As the FCC has recently said, overlashing often marks the difference between being able to serve a customer's broadband needs within weeks versus 6 or more months when delivery of service is dependent on a new attachment. The FCC has also said that from a service deployment perspective, the practice of overlashing greatly facilitates the ability of providers to efficiently and cost effectively expand their service capacity and roll out service to customers. From a resource utilization perspective, the practice of overlashing helps optimize use of capacity on existing utility poles by eliminating the need for entirely new wired attachments, thereby minimizing the capacity burden on the poles. At the very minimum, we request that the Commission ensure that utilities cannot cut back on permissive approaches to overlashing that exist under currently operative utility tariffs. Third, we've touched on this in a number of different comments we've submitted to the Commission, and we continue to believe that it's very important for the Commission to address in its regulations. We ask that the Commission expressly prohibit utilities from imposing attachment terms and policies beyond those that are specified in negotiated or approved agreements or tariffs. This is a very real problem that we've highlighted in our comments, and if it goes unaddressed, it threatens to undermine the Commission's regulations and policies. Because for providers to deploy facilities necessary for consumers to reap the benefits of broadband on a timely and cost-effective basis, the providers need reasonable, clear, and certain rules of the road that cannot just be unilaterally changed on the fly or on a whim by utilities. And finally, We've touched on this before as well, and we'd like to emphasize that the commission really needs to amend its dispute resolution process so disputes over pole access can be resolved when they actually matter. Disputes over pole access are time-consuming, they're costly, and they delay deployment. Unless they're resolved quickly and efficiently, they delay projects, they deter investment, which are necessary to provide broadband to customers. They also cause providers to actually lose customers. So it's imperative that access disputes can be resolved on a faster track, and we propose that the commission identify those disputes for resolution within 90 days. I'd also like to just briefly touch on a few of the points that Mr. Langley made in his opening remarks and respond to those. Mr. Langley discussed the self-help remedy that the commission adopted. From our perspective, that's absolutely critical, and it makes sense for a number of important reasons. First of all, attachers use the utilities contractors. Absent that self-help remedy, attachers don't have one, which means that broadband deployment gets delayed. And I'd also like to emphasize something that I pointed out during one of our earlier sessions, which is this is an issue that's been litigated before, and the utilities lost it in the Ninth Circuit Court of Appeals. That's a sound decision, and the issue shouldn't be relitigated here now. Mr. Langley also touched on the rules' impact on existing tariffs. Tariffs adopted without the benefit of these rules should not take precedence over the rules themselves. That simply makes no sense, and it would defeat the entire purpose of having clear and consistent rules. It would mean that attachers are once again left to negotiate and potentially litigate rates, terms, and conditions in a piecemeal fashion, which of course just turns into delays and deterrence when it comes to rolling out broadband in rural areas, which these rules are geared to promote. One other thing I'd like to point out is when we talk about the number of applications, the number of attachments that are going to be made, what has gone on in the past is not necessarily an indicator of what's going to happen in the future. The number of applications that our association anticipates making are going to be far beyond what they've made in the past, in part because of federal and state funding that's being made available for rural deployment. So we would ask that the commission evaluate numbers of attachments in light of clear public policy goals and available funding to deploy rural broadband on an expedited basis. And finally, I would just like to touch on the final invoice issue. We've discussed this before, and I won't belabor it, but 6 months for a final invoice is just not commercially reasonable. 90 days, which the commission has adopted, is practical, it's reasonable, and it's appropriate for attachers. And with that, unless there are any questions, I will pass the floor to Ms. Patricia Crafton for some additional remarks.
I do have just one clarifying question, and with regard to the proposal to amend the commission's dispute resolution to shorten it from 180 days to 90 days. Is that only applicable to a denial of access and not to a complaint regarding rates?
Yes, exactly, precisely. Any other disputes over rates or terms and conditions can be decided on the existing timeline. We ask only that denials of access be resolved very quickly because that's when it matters. If an access dispute is prolonged, it becomes costly and it ultimately just delays or frustrates the entire project, which means a customer is lost or a customer doesn't get service on any kind of reasonable time frame.
Okay, thank you.
Okay, thank you, Paul, and thank you to the commission and staff for giving me the opportunity to comment in this important rulemaking from a more purely economic perspective on the issues involved with broadband provider access to utility poles. As my paper on pole policy and the public interest elaborates, from an economics perspective, efficient pricing practices consistent with the fundamental economic cost causation principles along with low transactional or process-related costs of entry for broadband provider access to utility poles, promotes the best possible utilization of resources and also maximum gains to consumer welfare. This is because the pricing practices consistent with economic principles create real-world conditions that facilitate the timely access to high-speed quality broadband services for consumers, especially in unserved, hard-to-reach areas. In contrast, the present utility pricing practices, including those that create impediments to broadband provider access to utility poles, result in sizable lost consumer value and reduction in societal welfare. Now, foremost among these practices is the pole owner shifting to the broadband provider the utility's total loaded cost of new poles, regardless of the fact that these pole replacements are a long-term inevitability for the pole owners in connection with the provision of their own core utility services and would occur in the absence of the new attachment requests. And as Paul alluded, this practice is becoming a very serious impediment given the increased number of applications that are going to be occurring with the grant funding and the efforts to get broadband out into the unserved areas. This is going to be an unprecedented volume. As spelled out in my paper, this is not just an interesting theoretical problem for economists to write about, although it is interesting. There are serious real-world consequences to the consuming public and overall societal welfare when pole attachment costs, a critical input to broadband deployment, substantially deviate from socially optimal and efficient levels in accordance with established objective economic principles. On the demand side, my paper estimates economic harms to Kentuckians from the present inefficient make-ready practices as compared with the policies advocated by the KBCA in this proceeding in the form of foregone consumer value losses that would be associated with the widely acknowledged and demonstrated benefits of a high-speed, quality broadband connectivity. These estimates put these amounts in the range of $119 million per year of lost value from delay of broadband availability, roughly upwards of a total of $2 billion when looked over the lifetime of the pole asset in present value terms. And these estimates are conservative. They're only looking at direct consumer value effects. They don't take into account all the available public funding dollars that could go underutilized as a result of these inefficient make-ready practices. They also don't reflect the multiplier positive externalities on the supply side that broadband is known to generate through local and regional economies. So let me elaborate on a few key reasons for this disconnect between the present make-ready practices and those that would be aligned with economic principles and that best promote the public interest. So pole owners, regardless of the tag status of the pole, enjoy significant operational, strategic, revenue-enhancing, capital cost and tax savings benefits from pole replacements, even when the poles are not red tagged at the time of replacement. And my paper goes into this in more detail. When attachers are forced to bear the cost of replacing these partially depreciated poles, it's going to result in fewer or delayed broadband infrastructure investments and reduced service availability to the great detriment of unserved areas throughout the Commonwealth. This practice disincentivizes broadband deployment and investment for attachers, in effect gives the utility a significant unearned economic benefit from the pole replacement at the cost of consumer value. To ensure consumer benefits from broadband services in a timely and equitable manner, the economics dictate that the Commission should expressly prohibit utilities from requiring attachers to pay the full replacement cost of a prematurely retired pole and instead revise the regulations so attachers are only responsible for the remaining undepreciated value of the replaced pole, representing the temporal effect of the transaction. Now, this approach would avoid the imposition of substantial and unreasonable costs on pole attachers and would ultimately benefit the Commonwealth's existing and new consumers of broadband services, Without such prohibitions in the regulations, utilities will inevitably impede attachers and their ability to proliferate broadband access. And in closing, in terms of the public policy trade-offs involved, and there are always trade-offs in economics and policy, but given the pressing need to close the digital divide, there is much more risk from current inefficient make-ready cost allocation practices and inefficient pricing in terms of market distortions and disincentives to invest timely in broadband infrastructure, especially in unserved areas, than there is from enacting rule changes, such as proposed by the KBCA, that may reduce nominal flows of money to the pole owners, but that have a de minimis impact on electric customers overall, especially as those customers themselves stand to gain as potential users of broadband, and the pole owner stands to gain from significant betterment value from the replaced poles that should be included in the economic calculus. Again, I thank you for your time. I welcome any questions from the commission and staff.
I do have at least one question, and with apologies to Mr. Overstreet, Mark Overstreet, if he's listening. I always steal this line from him, but I went to law school because I was told there's no math. And so I've looked at your tables on your comments, and they sometimes make a little sense to me. But I guess I have a more holistic question with regard to how the undepreciated cost of a pole would be calculated, because would that require, let me take a step back. If a utility does not keep their records in such a way that they would know the undepreciated value of an individual pole, would KBC, would your all's proposal require the utilities to start keeping individual accounts for each pole to determine how it is depreciated, or what would the effect be? Because it's my understanding, once again, no math over here, that electric utilities, at least in Kentucky, do not maintain records for an individual pole. And I might ask for elucidation on reply comments or response comments from LG&E and KU or Kentucky Power if they have that information. But are you aware, Ms. Crafton, of how the utilities maintain the books for the depreciated value of a pole?
Yes, those are great questions. The record keeping does vary utility to utility, but what is advantageous is that we have a history of pole attachment regulation on the recurring rate side that we can borrow from. And my paper does go into this in the appendix, where I actually provide examples of how aggregate book data that is used for the recurring rate formulation can be used to calculate an average book value, with the potential to have an increment or a decrement where there's evidence to show a pole is older or younger than average. So the same techniques that are used on the recurring rate side that every utility largely will have to keep books to provide that data can be used for this purpose. I also provide another methodology that has been used where even that data is not available, where based on current pole costs, we can use existing cost indices to effectively deflate the value and rederive an average book value for a pole of average age. So I do address this in the appendix to my report to show that this is not theoretical. These figures can be determined on an average basis using existing data that utilities do keep. So this would not require additional data recording any different than what they are required to keep in consistent with accounting rules plus their own requirements and there are methodologies to do so. So those are spelled out in the appendix. I do have some sample tables where I work through examples showing that these were readily calculated type figures.
Okay, well, thank you very much. I don't have any further questions.
Thank you.
All right, who's next?
If the folks from the powers are done, I believe it's me, correct? Matt DeTora, CTIA.
Well, as everybody's spoken for the Kentucky Broadband and Cable Association, I know they had some other people listed.
Of course.
Mr. Gardner, do you
Yes,
have
sir.
anybody else that wishes to speak?
No, sir. We do not.
All right, thank you. Sorry, Mr. DeTora, I stole your thunder. Why don't we start over again, and you can start from the top.
No worries. No, nobody has any thunder this late in the hearing, so I will do the next best thing and attempt to keep it brief. First of all, thank you, Mr. Penny, and to the commission. I think as Mr. Langley said up front, I'll start with introducing myself. I apologize. I'm Matt DeTora, CTIA. I represent the wireless industry on behalf of carriers, app providers, and all the folks who make wireless possible. Thank you to the commission. Stakeholder input, as Mr. Langley said, is really important in all of these. There's the kind of pessimistic view that says that, a good compromise leaves nobody happy. But I think if you look at the glass half full, good pole attachment policy is really a win-win for all parties. Attachers get their chance to be in the right of way. Municipalities can keep one right-of-way set of poles. Pole owners can rent out space on their poles that would otherwise, go fallow. And of course, consumers benefit the most of all when there's quick, efficient deployment. And I think, as Mr. Keller noted previously, this really is a crucial time for pole attachments. Not just because of the impact on the economy and coming out of COVID-19, but in particular for wireless as we move into the fifth generation of wireless. And one of the major technical differences about 5G, as you may have heard, is that in a lot of ways, the prevailing move for 5G is away from the sort of large macro tower, gigantic cell tower, or in some cases, as my wife likes to laugh at, the large monopole dressed up as a tree alongside the highway, and to small cells that are going to be closer to the consumer and enable us to lower latency, increase capacity, and increase speeds for consumers, and really enable a whole host of amazing new things. To do that, it's going to mean a lot of small cells, and it's going to mean a lot of pole access, and even for larger deployments, because won't get rid of large macro cells entirely, we're still going to need access to the poles. And I think over the course of the past couple of decades, both in Republican and Democratic FCCs, we've seen a constant movement to try to reduce these barriers to deployment. Again, widespread agreement that the quicker we can get equipment out on the poles and out into sites, the better off consumers are. So we filed initial comments back in September this year regarding the proposed rules. I won't rehash all of those there, but we noted we called for rules that were substantially similar to the FCC's. Of course, Kentucky is a reverse preemption state for pole attachments and therefore has jurisdiction. But in the majority of states, including a number of states that have adopted the FCC's rules wholesale, it's the FCC regime that has proven effective and is the one currently in place in, I believe, 30 plus states at present, if you include ones that have adopted the FCC rules wholesale. And we're heartened that the commission is taking a number of steps here that do bring Kentucky's rules more modern and closer to the FCC's. We particularly support the implementation of shot clocks. We've seen over the past 2 decades that enforcing reasonable timelines for access and make ready has proven to significantly reduce delays. Also, one-touch make ready and its importance to getting backhaul out to the poles and self-help remedies. Again, these are things that are generally win-win. They place the emphasis on getting the survey and make ready done in the hands of the people who are the most motivated, which are the attachers. And commensurately, it takes some of the administrative burden off of the utilities while still allowing them to maintain control over the safety of their networks. Now, there are a couple of ways that this is accomplished. One, of course, is, as has been noted here, there is a list of approved utility contractors that is used. Also, I noted the proposed rules, much as the FCCs do, allow for a representative to be present at any work. But I've dealt with pole attachments in a lot of states at this point. We understand the safety concerns. They're the utilities networks, and safety is as or more important to wireless attachers as it is to the utilities. But we found that the dual claims of, well, there are no delays, and, well, this self-help remedy isn't the way that it should be approached, they kind of work against each other in a way, because if there are reasonable timelines for access and make ready, then the utilities have and still have all the control in the world over whether the self-help remedy is going to be used. It's only going to be used in cases where there's a delay, when reasonable timelines that the commission has set for access and make ready have not been met. So with that ultimate control in the utilities' hands, there's kind of a one or the other here. Either they're not meeting their timelines, or if they're meeting their timelines, then there should be no issues with self-help remedies going forward, because if they're meeting their timelines, they're not going to be used. So, we have submitted comments. We submitted our comments on Wednesday. And from a broader perspective, Kentucky is kind of unusual among states in looking at handling pole attachments via just this tariff system. And again, I'm not saying that's good, bad, indifferent. It's certainly different from what the FCC does, and we've emphasized, that there are advantages to what the FCC does, but there are certainly advantages to keeping it local as well. The commission's expertise in dealing with disputes, for one, is a good reason for states to keep that jurisdiction in their hands. But we are still a little concerned that the rates, terms, and conditions of attachment are being left largely to tariffs. Now, much as federal law does, Kentucky law calls for just and reasonable rates for pole attachments. It's in Kentucky statute. And there are a number of other requirements in there that are similar to ones that you see at the federal level with regard to just and reasonable rates, terms and conditions, non-discriminatory terms and conditions. And we do feel that it's important that the commission at least put some sort of flag in the ground on what it considers to be just and reasonable for rates, terms, and conditions. And, as has been noted by, both parties on the attacher and the utility side, we're seeing rules go into place that call for new tariffs here. So every attacher and the commission is going to have to review each tariff for legal and contractual concerns for each utility that they're attaching to. In an ideal world, of course, this would be a very smooth process, but there are a lot of moving parts here, and there are almost certainly going to be disputes that are going to have to be settled by the commission. And at that point, if those disputes arrive over the terms and conditions of access, or if they arrive, as has been noted, rate disputes can be handled a little later, but any disputes over terms and conditions of access are going to happen at what is truly a critical time for Kentucky's economy as we move into 5G, as we move out of COVID. So what we've asked for in our comments is the commission to set up a model tariff and to include it with the proposed rules. Now, a model tariff would set guidelines for what the commission considers to be just and reasonable rates, terms, and conditions. Eventually, the commission is going to do this anyway. It's going to arrive at these rates via disputes from one end or the other, and eventually we're going to have disputes where the commission is going to say, okay, this rate is okay, this rate is not okay, and we'll move towards what the end number ends up being. But it's better to do it in advance. It saves everyone a lot of time, a lot of effort. We, of course, and as Mr. Huntenhauer noted, we support the FCC rates that have been in place in over half the states and have held up to legal challenge about what is just and reasonable for compensation for pole attachments. But I think regardless of what the commission chooses for rates, it's important to set that marker in the ground earlier rather than later. We've also asked that when this model tariff is set up, that those deviating from the model tariff at least provide some justification for why they're doing so. And again, this sets almost a safe harbor from the commission, or we see this as reasonable rates, terms, and conditions. Why do we need to deviate from this? And if the utility can demonstrate that there's a good reason for that, that's great. You end up approving that. But again, we head off disputes by doing a lot of the hard work up front. And again, this can be a very win-win situation. It reduces the administrative burden on everybody. Utilities don't need to write new complex tariffs. The commission, of course, is going to face less disputes, and the attachers can get along with what we need to do, which is get access and make ready the polls. We also noted in our comments that, regardless of what the commission chooses to do or not do with regard to a model tariff, the proposed rule should include some sort of notice requirement for changes to tariffs. Poll attachers begin in a tough negotiating position because of the fact that simply the utilities have this control over the right of way. It's a regulated monopoly. The more time that attachers have to review the tariffs, less possibility of error and fairer it is to all parties. And we know, as we got the email blast the other day, as the commission is going back to an e-docketing system, it'd be good to have all these tariffs in one place, publicly accessible, one docket, easy to find. And then, we concur with the comments from Kentucky's Broadband and Telecom Association with regard to shortening of dispute timelines. Right now, as noted in the rules, it's 180 days with 360 for good cause, and there's really no relief if the commission does go over. I mean, you could appeal to a higher authority, but at that point, you've already faced a year's delay in getting access to polls. And this compares to the accelerated docket at the FCC, which has a 90-day timeline, which seems much more reasonable, especially for matters of access and make ready for polls. Some other states, we cited Maine as a 5-business-day rapid response for simple complaints set up there. Obviously, Maine is a much smaller state than Kentucky is, but the comparison is worthwhile there. It's a pretty significant disparity. So, again, if a model tariff is included in the rules, that means less disputes down the road. That means less administrative burden on the commission, and that makes sense that the deadline should be shortened commensurately, excuse me. But we do feel that 90 days is a much more reasonable timeline for disputes. And I think everything else will be included in our comments, which, as I noted, have already been filed with the commission. And thank you, Mr. Penny, for allowing us to speak today.
All right, thank you very much. I will say the time, we're better on time than I thought, so I appreciate that. So if anybody would like to make some reply or response comments, I would entertain that. I would like that we limit them to about 5 minutes, if not shorter. And of course, they're purely voluntary. I don't require them of anybody. But I may have a follow-up question for one of the commenters after this, but I will take response or reply comments in the order in which we took the initial comments. So Mr. Langley or anybody on behalf of Kentucky Power or KU and LG&E, if they would like to speak, I'd like to hear what you have to say.
Well, thank you, Mr. Penny, and I will keep it under 5 minutes. There are actually 4 points that I want to address. One that was raised by Mr. Reinhardt, one that was raised by Mr. Warner, one that was raised by Ms. Crabton, and one that was raised by Mr. Datura. The first is the point that Mr. Reinhardt made about the Ballard decision and how there couldn't be undue preference for any class of provider. And we don't disagree with that concept, but that's exactly why joint use agreements need to be excluded from the rules, because the commission has to look at those agreements to understand what they mean and to understand, first of all, whether there even is a rate. It's interesting that Mr. Reinhardt raises that because in Kentucky, 2 of his agreements with with KU and with Kentucky Power both have buyback provisions. And so they are less dependent on any sort of annual rate than they are an obligation that one party in the minority of poll ownership or out of parity buy back polls when they drop beneath a particular percentage. That's just an example of the type of provision that the commission would need to review to understand whether there is in fact undue preference. The second issue is that I wanted to address was the point Ms. Crabton made about make-ready poll replacements. And there's the accounting life or the book life of an asset, and there's the useful life of an asset. And the fact that a pole may be at or near full depreciation on the books doesn't mean that it can't stay in service for the benefit of electric ratepayers. And electric ratepayers shouldn't be funding now a pole that they don't need for electric service. And so while in theory there is appeal to what Ms. Crafton is saying, in practicality, there's not, because it would be forcing these costs in an untimely manner on electric ratepayers when they don't even need a pole to continue the provision of electric service. And then say it's chartered on day one, but then it's a CTIA member on day two. Does that mean that the electric utility bears all of those costs that are not capitalized, such as the O&M associated with transfers? We're talking about big dollars here. This is not a step the commission should take. Third, the tariff point that Mr. Warner made and that Mr. Datura referenced. LG&E KU has a 25-page tariff on file with the commission. If all of the provisions in this are so unjust, so unreasonable, where were these objections in 2016? Where were they in 2018? Where were they in 2020? If the commission is looking for a model tariff, there's already one on file. And this idea that somehow the rulemaking is an opportunity to unwind all of the things that they didn't bother to address in the three previous proceedings really just doesn't hold water. The last point I'll make, because I know I'm cutting close to 5 minutes, is the self-help remedy. I think Mr. Warner addressed this also, and Mr. Datura did as well. Specifically, I want to address the point Mr. Datura made, which is you can't argue that utilities aren't a source of delay or that they always meet their deadlines, and at the same time argue that there's no need for a self-help remedy. That is what I think would be called a false dichotomy. Because there is, in fact, the third situation, which is the situation that we think exists, and that is only very occasionally will that occur. And so the question is, does that rare occasion when a utility or its make-ready in the supply space might be a source of delay justify this extreme remedy? And Mr. Warner alluded to the fact that it was approved or validated by the Ninth Circuit. The Ninth Circuit did not address the policy of self-help. They merely addressed whether the FCC had acted within its discretion. And we respectfully submit the Kentucky Public Service Commission should and can exercise discretion in a different way. Thank you.
All right. Thank you very much. And I forgot to time you, so I assume you came in under 5 minutes. All right. Anybody else from Kentucky Power, LG&E, and KU want to make a comment? Okay. Then I will move on to Duke. Oh, sorry, Ms. Judd. Did you have? Okay. Wait, I'll move on to Duke. Does anybody from Duke want to make any response comments?
I will ask Scott or Jeremy if either one of them have any response comments to make. Otherwise, we won't have any.
No, I think we're good at this time. Thank you.
All right. Thank you. Mr. Reinhardt, anybody from AT&T Kentucky?
Yes, Mr. Penny, thank you very much. Just one response to the power companies as to joint use agreements. I think, one of the things that we see in joint use agreements is that, and the power companies' desire to hang on to substantially higher rates than they would get through a tariff is premised on the belief that history is on their side, or history should not change. AT&T as a local telephone, local exchange carrier, is in a very much declining market for itself, and the power companies still maintain natural monopolies. So the concept of trying to force telephone companies to buy into a particular share of polls to pay extraordinary rates for the identical attachment that their competitors are paying is misplaced in time. That concludes my comment.
Okay, thank you very much. And then, so for the Kentucky Broadband and Cable Association, are there any response or reply comments?
I don't have any further comments.
Okay.
I do have a few comments I'd like to respond to Mr. Langley.
Okay.
First of all, I appreciate his acknowledgement of the appeal in theory, but I think as my paper sets forth, there's more than theoretical appeal. There is real practical, real world benefits that would accrue to consumers in Kentucky from the speedy, timely, and widespread deployment of broadband, that more economically efficient pricing of the replacement poles would provide. While he is correct that there is discrepancy between accounting life and useful life, they do impact each other. They're related. They're not totally independent, because the depreciation rates and the capital recovery to the utility is based on accounting life, but those accounting lives do change as data is available on what the useful lives are of the plant. And actually what we've been observing in those studies is typically a shortening of those lives as utilities increasingly face requirements to build more resilient distribution networks, to harden their poles, and also to improve those poles to handle growing primary needs. Again, I think that the methodology embraced by the KBCA and expanded in my paper actually reflect also the useful life as it reflects into the accounting lives. I would also comment that, as typical, the utilities calculus doesn't look at the total betterment value that accrues to the utility and its consumers when these poles are replaced. So it's not just the cost of the new pole that the utility would bear some more cost responsibility for, but offsetting that are these quite substantial betterment values that my paper expands upon. Thank you so much.
Okay. And I do have a question for, I guess, for the KBCA in general, but Ms. Crafton, I think you pointed to this in your paper, where when you're talking about the pole replacement, how it could, the way that the commission has proposed the red tagging cost and other costs of replacing the poles, that it could be an impediment to serving, unserved or underserved areas. Is that correct? Am I misstating your position?
No, that is correct, because the costs are substantial, and so they impede ability of the providers, okay, to meet the cost requirements and investment requirements. It simply raises the cost of their entry, of their provision of service.
Okay.
So that is going to impede their ability to get access out timely. And again, each month of delay reduces consumer value and benefits to the local economies.
Well, how does the cost of a pole replacement affect the timeliness of a rollout if there is a dictated formula for the cost of a pole? Say, for example, either the commission changes it or the commission keeps it as it is.
Well, that I will answer certainly from an economic standpoint, but I might invite the companies themselves to comment on this. It's a cost to the provider. So when they're looking at the cost to roll out service, the costs of pole replacement have to be taken into account in terms of the monies they need to fund and these ventures. And obviously, the higher the cost, this is true for any good or service, but as your costs increase, then you have set budgets and timelines and investor agreements, and it absolutely reduces the resources that can be devoted to that deployment as the costs go up.
Okay. And then so with regard to, I think you mentioned the RDOF a few times in your paper. And I am by no means an expert on this, but isn't there an obligation to serve for a utility or a broadband provider that has received the RDOF awards?
There are obligations in connection with those grant fundings, but there is, again, the timing of reaching those obligations that will be impacted. And again, the analysis I perform looks at the impact of delay. It's both impeding the investment, it's also delaying the investment as the investment dollars that the broadband providers have to spend, okay, are siphoned off, if you will, used up to pay these sort of inefficient prices for one of their inputs. So obviously this is how markets work. To the extent your input prices are lower, then you're able to roll out your service faster and more broadly, and also to areas, this is important, that are more costly, more subject to these replacement pole costs. It's sort of a mismatch with public policy. You actually want to get out into the harder to reach areas more quickly, because those consumers are in more dire need than sort of incenting the money to flow to the areas where there are fewer replacement poles needed, which may be areas that don't have as high consumer loss from not having service. So in general, the more efficient, the more closely your input price matches an efficient price, then you're going to get service rolled out more broadly to higher cost areas more quickly.
And would these areas include areas that were not included in the RDOF auction then?
Absolutely they could, although my understanding of the RDOF goes, I think, has a pretty far reach into unserved areas. But clearly, from a broadband perspective's point of view, they have grant obligations, but they're also looking and would be incentivized to go even beyond RDOF if the input prices that they're forced to pay for access to this vital essential facility go down. I mean, that's just how markets work for any business. As the cost to provide your service go up, it's going to reduce your ability to get more service out and more quickly.
Okay. And then one final question.
Patricia, Mr. Penny, this is Dan Gonzalez at Charter. Maybe I could just clarify with your question with respect to the RDOF program.
Okay, yes, please.
The FCC's RDOF program only funds deployment to unserved areas. The FCC went to great extent to try to map areas across the country and made those areas available for auction, in which providers came in and said, in a reverse auction, who could provide service at the most cost-efficient level and basically at the least amount of subsidy, which is very different from previous kind of subsidy programs. But it was aimed directly at providing service at unserved areas. So the efficiencies that Patricia identified are critical. And let me just emphasize, so is the timing, because we are under strict build-out deadlines under the FCC RDOF program. And if we don't meet those deadlines, we are penalized by the FCC. And the RDOF program is not the only grant program that's out there. There'll be more federal programs coming down the pike. There was CARES Act money that was made available, and state programs, and many of them have real specific build-out deadlines. So that's why the timing piece of this and the precious investment dollars that we have and the cost efficiencies
from the critical input, which is poles, is critical for our investment and deployment activities in the state.
Okay, so then, as the cost of pole replacement rises or stays as the commission has proposed it, that takes away, as you said, the precious investment dollars for deployment, and thereby slowing down deployment. So then the broadband provider does not meet the obligations under whatever federal program it is, and the broadband provider is further penalized?
Look, we have to obviously make our investment calculus based on what those cost inputs are. And what I would say is it also takes away the opportunity cost that we have to invest or possibly look at additional programs. As you know, the federal government right now is looking at another round of broadband infrastructure potential subsidization. Those subsidies only cover part of the cost. As my colleague, Mr. Keller, had mentioned earlier, we have made our own significant commitment of our own investment capital to ensure that these programs, that we meet our commitments and that we build out. So with those limited capital dollars, we're trying to serve, obviously, as many get connected to broadband, as many, I believe, Jason, there were now, the FCC has said there are 300,000 Kentuckians who are currently unserved by broadband. So, and as Patricia noted, they're most likely in the highest cost areas of the state to connect. So that makes these broadband investment dollars so critical to be able to target them and deploy them as quickly as possible. Okay, all right.
If I could build on that, Mr. Penny, just one note to build on something that Dan mentioned. The RDOF, and just to provide a little bit more scope on how we see this problem of rural broadband and the remaining unserved even after the RDOF auction results came out. So the Federal Communications Commission has identified, as Dan indicated, about 300,000 Kentuckians that don't have access to broadband today. The RDOF auction is expected, not just with Charter's piece of it, but all providers, to address approximately 1/3 of those. So we still have a significant number of households across the Commonwealth in the hundreds of thousands that are not going to have access to broadband even after the RDOF auction. I'll give you an example of that. So I mentioned Scott, the judge executive from Scott County, Kentucky, in my comments. We have identified an additional 5,300 homes in Scott County over and above their RDOF results there that don't have access to broadband today. And so those are going to have to be addressed through some other means, likely through significant investment in private capital. And so that's where we see these issues come into play in a very real world way in order to expand service to as many of those continued unserved homes in Scott County and in nearly every county in the Commonwealth. We've got to have these efficient and effective rules in place that address things like pole replacements to help us expand service so 100% of the Commonwealth has access to broadband.
Okay, well, thank you very much. I don't have any further questions for you all. And I think that the last commenter would be Mr. Tatura, if you have anything else to say.
Thank you, Mr. Penny. Just responding to what Mr. Langley had said, he noted that, suggested at least that the commission has a model tariff. It's the 25-page one that's already been filed and not contested. But just because that tariff is acceptable doesn't mean it's the right balance or fair one or that meets the state's continuing policy needs. For one, as Mr. Reinhardt noted, that tariff, as all tariffs are, it's not negotiated from a level playing field. And I'd use an oversimplified analogy here, but if somebody has one parking spot in front of my work that I need to get into, and they're going to charge me $250 a day to get in there, it may not be fair, it may not be reasonable, but if I'm going to lose $300 a day not being able to get to my job, I may end up taking the parking spot. again, a bit of a gross oversimplification, but it illustrates the problem that Dan Reinhardt brought up, which is this is a natural monopoly, and it's the commission's role to step in and make a balance for that those uneven negotiating positions. And I'd also note too, you know, as I sit in my basement participating from Maryland in a Kentucky virtual hearing, that circumstances change. Circumstances change over the years, and there may need to be a rebalancing of what should be fair and reasonable as time goes by and as the state's priorities change. And again, of course, you know, that's the commission's roles. You know, as far as the second point go, you know, the third option that, you know, self-help in the supply space is, I think there's a fundamental disagreement here on that. It's extreme, but, you know, I'm not going to go into that here. I think there are plenty of records that have been assembled. You can look at the FCC's 2018 order in which utilities made all the same arguments about that, or you could look at, for example, at the dockets in Pennsylvania or West Virginia, which subsequently adopted the FCC's rules, including those provisions wholesale. I'm not going to go into it here, but those are available as dockets and supplemental material if the commission wants to take a look at it. And that's all I have. Thank you.
Okay. Well, thank you very much. That concludes the comment portion. Does anybody have any final matters they want to ask about? Let's limit it to more procedure. I think we've had plenty of content. Okay, well, there being no other comments, I do want to say we will, once we have all the written comments received, we will post them to our website. I will give notice to you all once they are posted. And then in about 5 minutes after we conclude this hearing, I'm sending a letter to the Legislative Research Commission telling them the commission needs more time to file its statement of consideration. So that will extend the deadline by 30 days from August 13th to September 15th for the commission to file its statement of consideration. All right. There being nothing else, thank you all very much for your comments, and thank you for your filed comments. And I look forward to reading the filed comments that have not been sent just yet. And everybody have a very good day.
Thank you.
Thank you. Thank you. Bye.